Thanks everybody for coming today.
Yeah. We'll go ahead and let me get started. I know we've got a lot to cover in the next 2 hours, and we appreciate your involvement and wanting to learn more about our contract. My name is John Smith. I'm here with the CCRA Board of Directors. We're excited to be bringing this training, our first virtual training class to you via Zoom on the contract. We had an earlier contract class on March the 9th where we actually did the training live in our new building. We're excited about the new building. I know we haven't had a chance to use it because of COVID, but we're excited about the opportunity to get in there and have an open house as soon as we get out of this this COVID era. But we had 53 attendees for that training. Today we have over 360 for this training. So we're learning that this type of training venue will give us the opportunity to touch more agents. So we're excited about that. I'm joined today with Matt Carroll and Gary Pickering. I'll introduce Gary again in just a second. I wanted to introduce Matt to you. Matt's our 2020 contract chairperson. He's done a great job. His whole committee, I know there's several committee members on this webinar today, and we appreciate your participation in our association, what you do for the contract committee. I wanted to give Matt just 30 seconds if he just kind of give us an update as to what's going on with the contract, maybe a new form that the contract committee is rolling out. So Matt, thanks for being here.
Yeah, absolutely. Thank you, John. So yeah, the contract committee, I've been chair since 2017 or 18, I don't remember. We've released a few forms the last 2 years. Usually our goal is we begin at the beginning of the year with a new committee, and then by the end of the year, we've finished whatever form it is we're working on for that year and then release it out. This year, the form that we're working on, we're about halfway through, which is good because about halfway through the year, we're working on a backup offer form. So, you know, that there's an actual, there will, once we can get this form done, there will be an actual process to how backup offers work, because we're seeing so many multiple offer situations and things like that. Last year, we released a multiple offer process form. So, you know, if you guys haven't been using that form or don't know about it, you know, ask your broker. You know, we've got those forms available. They should be on zip forms for you. So we did release the multiple offer thing last year, and then kind of on the heels of that, people talked about needing a way to do backup offers instead of just writing backup offer on the contract and trying to hand scrawl some terms on there. So we're trying to systematize that for everybody. So that should be hopefully, you know, done by the end of the year and released sometime around first of next year.
Good. Well, thank you, Matt. We appreciate what you guys do, and your committee. Certainly pass along our thanks to them, and we look forward to seeing what's going to be coming out sometime this year. Matt,
hopefully we're still in a situation where we have a bunch of multiple offers going on at the end of the year this year.
Exactly. Matt and I will be, our role today will be panelists. We will be taking questions, and you can go to the bottom of your screen. If you have a question about the contract, you can either use the Q&A button or the chat button. Matt and I will be monitoring that for Gary. Gary will be doing all the talking today, and we'll be helping with questions. Also, we're going to be putting up some polling questions periodically. I'm going to ask Kathleen if she'll just put up the first series of questions. We would like for you to answer these questions. These will help us kind of see what your experience is, how often you use the contract, and you can simply do that with your cursor and answer those questions now. As Gary speaks today too, we'll be putting up questions that will be pertinent to the paragraphs in the contract that he'll be speaking to. We are not going to stop Gary. He's going to continue to talk, but if you'll just quickly answer the questions, that'll help us kind of see where we need to place emphasis and kind of see, you know, what the knowledge level of the agents are and where we need to put emphasis for future videos and meetings.
Yeah, there's 3 questions there, John. Tell them.
3 questions.
Yeah, the 3 questions. Let me scroll down.
Yeah, there's 3 total questions.
If you can't submit, you've got to scroll to the bottom and hit the submit. Make sure you're answering all the questions. It looks like it was just 1, but you got to scroll down.
Yeah. So if you'll do that quickly, we'll give you a couple more seconds to do that, and then I'll ask Kathleen to take it off the screen. Okay, Kathleen, you can go ahead and take that off for now. Okay, well, thank you for doing that, and we appreciate it. Well, I'm going to introduce Gary. He doesn't really need an introduction. Gary's been very involved with the association through his sponsorships at his law firm, Blair Cato. We appreciate their continued support. Gary volunteers his time with the contract committee and with training, different training venues. So we appreciate Gary's involvement with us, and we've got a lot to cover today. So Gary, we're going to turn it over to you.
All right. Well, thanks, John. Thanks, Matt, for having me today. As always, when I start these seminars or webinars, I always like to thank Kim and Taylor for the tremendous amount of work that they have done at the association since taking over, but even more particular during this COVID virus period. They have gone, in my opinion, way out of their way to make sure that everybody in this association is up to date on what's going on. Byron and Nick over at the state association has also done a fantastic job. Kathleen has also done an incredible job getting these webinars put together. So we really appreciate all they've done in the industry to make sure that everybody knows what's going on. I think this is probably my third webinar I think I've done with the association, in addition to doing the realtor ethics class. I think we've done 3 or 4 of those and got several of those still coming up. So big shout out to them. I would be remiss if I didn't at least mention, if you appreciate what the association's doing for you at the state and the local level, when times are good enough for you and you have the money to do it, I strongly suggest you donate to RPAC. This is what this association does. They're keeping you educated, they're keeping you protected, and they have gone out of their way, pushing as hard as they can with Governor McMaster and everyone to make sure that you were able to stay open, that you were deemed essential. Because remember, nobody here was deemed essential when this thing first started, and it's because of the work of South Carolina Association of Realtors, and as well as the work of CCRA and the BIA with Earl McLeod that we were deemed essential. So thank them the next time you see them, because they kept us all getting money. That's very important. All right, with that being said, I'm going to roll right into the contract. I'm going to go ahead and screen share my contract here with y'all. And hopefully, Matt, y'all can see that, I hope. Let me know, Matt, do you see it?
Yeah.
All right, so what we're going to do is I'm going to go ahead and start going over the contract. Give me 1 second here to pull up all the chats and everything. Once I share the screen, all that stuff kind of disappears, so I need to pull that back up. All right, very good. Now we're good to go. All right, so this contract we're looking at today is a CCRA contract. It's a contract we've been using since around, I think it's around 2008. We started writing it in about 2006 with Dan Pater, who was a broker in charge at Russell Jeffcoat, heading up the committee. The contract, I think, has done an excellent job of withstanding time and changes in the market. If you think about it, since the contract has been in place, we've had an economic collapse of the late first decade. We've also had coronavirus. We've had buyers markets. We've had sellers markets, and this contract has stood up during the test of time. So I think it's done an excellent job of doing what we want to. Or wanted to do. We've tweaked it here and there over the years, and I think it's in a good position right now. We'll continue to look at it, and we'll continue to tweak it as needed. One of the first things I want to talk about is when somebody submits an offer to you that is not on a CCRA contract. I get this question a lot. What should we do? Keep in mind, remember that your client drives what happens. And so the first thing you need to do is sit down with your seller and say, hey, we have received an offer, but it is not on a CCRA contract. It's either on the state association contract, or it's somebody's drafted their own contract, or maybe used a form contract from a different area, and ask and present to your client what that means to you and what that means to them. One of the best arguments for using the CCRA contract that I like to make to clients is that we've been using this contract for well over a decade. The lenders understand it. They know the time frames under it. They know what's expected of them under it. The closing attorneys know what's in the contract. They know what's to be prorated, how it's to be prorated. They understand all the terms of it. And you are able to explain the contract a lot better to them than having to get up to speed using a contract that you are not normally using. And so what I think, once you explain it that way to your seller, I think what your seller should do at that point is suggest to you, and you should kind of get them to that point, that you want to counter offer back on the CCRA contract. Obviously, you don't want to lose a deal today because of an argument over which contract to use, but I think if you explain it to the other agent that the reason you are responding on the CCRA contract is for those reasons, I think that will help you convince the parties to use the CCRA contract. And I do think it is important that we use our CCRA contract because that's what everybody's using in our industry. So let's start looking at it. At the very top of the contract, as y'all can see, we have this provision here. The buyer seller is licensed under the law of the state of South Carolina as a real estate license. Now, that is required by 40-57 of our statute. You are required to disclose when you are acting as a buyer or seller in a real estate transaction. Now, that may be different than the Realtor Code of Ethics, which only requires you to disclose when you're a buyer. It requires, if you're a buyer, to disclose as well as your immediate family. The seller, you're only required to disclose under the Code of Ethics when you're the actual owner. That's different than state law. State law requires you to disclose at all times. So keep in mind that it's not just when you personally are buying or selling, it's when your immediate family is buying or selling. It also includes if you are an owner of an LLC, a company, or shareholder, whatever, you have to disclose that your company or your LLC is also buying it. So if your mom, your dad, your sister, your uncle, somebody immediate family, I would say go ahead and disclose. Remember, it's never a problem until it becomes a problem. And what I mean by that is if you disclose that you are an agent and your parents are buying the property, there's not a single real estate buyer that's going to say that's a problem, or a seller who's going to say that's a problem, until a problem arises. And then the first thing they will tell you in a grievance for saying a grievance is that, had I known that the buyer's mother was the real estate agent or the buyer's daughter was the real estate agent, I never would have done the transaction. We all know that's a false statement. We know that's not true, but that becomes a big sticking point when we go to have a grievance. So go ahead and disclose. I never think disclosing that's a problem. I think when you don't disclose it, is when they try to make a big mountain out of a molehill there. All right. Under paragraph 1, parties, the contract's entered into blank date. That's a simple entry there. Now, buyers and sellers, you would think this would be very easy, but I do need to spend a little bit of time on paragraph 1. When you are entering a buyer's name, be sure that you spell the buyer's name correctly. I know that sounds kind of elementary, but we get a lot of contracts where the buyer has a very unusual name and it's spelled incorrectly. When we go to do the title search, we're now searching a name that is spelled incorrectly. Your lender may have the name different than we have, and so when you get the closing package, the lender has the name spelled one way, all the title documents have it spelled another way. Now we're creating a problem at closing. We have to now get a new package, or we have to re-update title. So make sure you're very careful. The best way to make sure you're spelling the client's name correctly is get a copy of their ID, take the name right off the ID so that we know it's spelled correctly. If you have a common name, such as John Smith, John Smith might be one of the most common names in America. You need to put the middle name in there as well, because when I do a title search, or we do a title search, we'll pull up a ton of John Smiths. If I have his middle name, it helps us narrow down things that pertain to our exact John Smith versus things that pertain to another John Smith. Under sellers, you also have to be careful with sellers. There's really no foolproof way of doing this. Right now, you can go to the Richland County online, richlandonline.com or lex-co.com, and pull up the most recent tax records. But keep in mind that tax records are not up to date. I have clients call me all the time in May that say they looked at the tax records and they're still not showing as owner. Well, that's because they closed in January or February, and the county tax assessor has not taken care of the ministerial act of updating their tax records. They only do it once or twice a year, so there's going to be a lag time there. Oftentimes the information is incorrect. I've actually had a client one time who called the tax assessor, said her husband had died, the police put her name as the owner of the property, and the tax assessor actually did it, even though there was no estate probated, there was no deed of distribution. So when we went to close it, the tax record shows the wife as the owner, but the husband is still owner of record, and he has now been deceased for several years. So it was a mess to take care of. So understand that tax records are not 100% accurate, but at this point, that's really kind of the best thing that you can do. I suggest not relying solely on the information that is put forth in the MLS listing, because you're trusting that the other real estate agent did a little bit of due diligence to make sure that information is correct. So at least go to the tax records and pull that information.
Hey, Gary.
Yes, sir.
A couple questions in the question and answer I just wanted you to address. There was one question about what if somebody's a fiance, you have to disclose that, and how do you disclose? Like if you're representing immediate family, do you check that box, or do you put it in paragraph 18, or what do you do?
There's no hard rule on what's deemed immediate family. Typically, immediate family is spouse, or domestic partner, children, parents is typically what we consider immediate family. However, why would you not just go ahead and disclose fiance? I mean, there's really no reason not to. It's not going to stop somebody from selling the house to you or buying the house from you. But like I said earlier, if you don't disclose it and later you have an unrelated issue, now all of a sudden they will try to make a big deal out of that. So you might as well disclose it. You can disclose it by checking the box. All that's required you to do is actually check the box. There is no requirement to provide an explanation. But I recommend you go to paragraph 18, check the box, and then go to paragraph 18 and say, the buyer is the real estate agent's fiance, or the buyer is the real estate agent's parents, or whatever.
Right. One other question while we kind of pause things for a second. Why do you search buyers' names?
Because we have to make sure that the buyer doesn't have any judgments or liens against them as well, because certain judgments, such as tax judgments, could take precedent over a purchase mortgage. There also could be certain things that as soon as the lender also wants to make sure there's no liens against the property before, or against the buyer that won't attach as soon as they buy it. So if let's say Matt has a $10,000 judgment against him as a buyer, once he buys that property, that $10,000 judgment attaches to that property. And so a lot of lenders require that those be satisfied prior to closing. But we also need to advise Matt that, hey, you have this $10,000 judgment. Once you buy this property, it's going to attach. And if they now decide they want to try to collect by foreclosing on the property, they may be able to do so if you have certain levels of equity in the property. So we need, as lawyers, we need to advise them what to do and how to handle that situation. The other thing with sellers is you need to be very careful. Sellers are pretty easy when it's an individual, when it's Gary Pickering, when it's John Smith, whatever, Matt Carroll, it's easy to write their names. But you got to be careful when it's companies, estates, and things of that nature. So let's talk real quickly about companies. There is no such thing as Gary Pickering Real Estate. That's not a company. That's just words. Gary Pickering Real Estate LLC or Gary Pickering Real Estate Inc. is a proper designation. So when you put the seller's name, be sure if it's a company or an LLC that you're including the comma LLC or the comma Inc. The other thing you need to make sure of is when you do have a company or LLC, go ahead and ask the client to provide you certain documentation to prove that they have the power to sign the contract. If I come to you and say, Blair Cato wants to buy this property, and you never asked me for the documentation, you don't know whether I have the power to sign on behalf of Blair Cato or if it's Rex Castellan or Cynthia Blair. So you need to be asking that information when you take the listing. You know, provide me some documentation showing who has the power to sign on behalf of the company, the LLC. If it's an estate, it's going to be the estate of the decedent. The trust is not going to be the trust of Gary Pickering. It's going to be Emily Pickering as trustee of the Gary Pickering Trust. And so that's very important. When you have a trust, my advice is pick up the phone or email your attorney and ask them how the contract needs to be written. Because when you write a contract that says the trust of Gary Pickering, that's not an entity. It can't hold property or sell property. It's the trustee holds and sells property for the entity. So it'd be Emily Pickering as trustee for the Gary Pickering Trust. When you have a church, just go ahead and pray, because it's very, very difficult. All kidding aside, when you do have a church, you need to call the closing attorney or call us, and we can tell you how to do it. Churches are very difficult. Some are hierarchical, some are congregational, some are nonprofit 501c3s, and some are corporations. So the way that you have to list their names are very difficult. So you're probably going to have to get legal advice on how to do that as well. All right, moving on down, paragraph 1. Because of the 2017 law change, we have the new initial places there for buyer and seller acknowledges the receipt of the disclosure of the broker relationship and client customer services in the transaction. That was an addition we had to add due to the 2017 law that requires that to be in a contract. All right, now we'll move down to paragraph 2, which is property. Again, you would think this would be one of the easiest sections to fill out. It is one of the most misused sections. It's the section we have the most mistakes in. You wouldn't believe how many counties we have wrong. People will put Richland County when it's in Lexington County. They'll put Kershaw County when it's in Fairfield County. And that causes a problem, and it can cause delays, because what happens when y'all put the wrong county is the closing attorney will send the title abstractor to the wrong county, and it causes delays on your title work. So what you want to be sure to do is to use as much information as possible here. I would advise you that real estate addresses mean absolutely nothing to us in a real estate closing. Addresses are for mail delivery and 911. It doesn't mean anything to a real estate closing attorney. What matters to us are lot and block numbers, tax map numbers, if it's acreage, some type of designation otherwise. So be sure that you do your homework. And if you're representing a seller, go ahead and ask them if they have a copy of their deed or a copy of their title policy so that you can find that information and provide that to the buyer. If the buyer just writes the address, go ahead and add their information you have when you send the contract back. The more information you provide here, the safer it is for you that you are selling the correct lot, and the safer it is for your client knowing that they're going to have the right property search. I could go on for hours about horror stories. I'll give you two quick ones. I had a situation years ago where the person really didn't look to see what was selling, didn't ask the questions, and what happened was there was a house and another lot that they were selling. When the contract was written, they only put the one, I think they put the address down, so the lawyer searched title based on the address. The address was for the lot. The vacant, or for the house, the vacant lot had a separate address. So about 1.5 years, 2 years later, the property went up to tax sale. Somebody bought it at tax sale. The homeowner found out about it. The reason they never knew about it was because the tax assessor was posting notices on the trees on the vacant lot. The homeowner always turned right to leave the neighborhood. You would have had to turn left to see the neighborhood, the sign in the trees. So the property went to sale. They tried to blame the closing attorney in Camden. I looked at the contract. I said, no, the attorney conveyed exactly what y'all told him to convey. The contract was not written properly. So the real estate agent unfortunately had to come out of pocket, our agency had to come out of pocket to fix the issue. And they basically had to go to the person who bought the lot and pay that person off. I think it was tens of thousands of dollars it cost the real estate agency. So you need to make sure when you meet with your seller and when you're sitting there with the buyer that you know exactly what you're buying and selling, and that you include the entire lot and the entire block. So be very, very careful with that. But I could go on for hours on the number of times that we've seen things that are incorrect there. And but I won't do that because that would take the whole class. So be careful. As much information as you can provide, the better off we'll be. All right, paragraph 3 is purchase price. Again, this should be an easy box to fill in. It often is a problem. We had a closing where we thought the price was, I think, 108. The seller thought it was 106. The buyer thought it was 100. The seller thought it was 109. The problem was that the handwriting was so sloppy and it had gone back and forth so many times through emails and printed off and changed and initialed and sent back that it was almost impossible to determine what the number was. And so there we are at the closing table trying to figure out, is this house being sold for between $100,000 and $109,000? 3 of us were wrong, 1 of us was right on what the ultimate price was, and they finally got to an agreement. But it required a whole new closing package and a couple-hour delay to get it done because they had to go back and re-underwrite the entire file. So be sure that when you write the price there, that your writing is clear. A lot of people's 0s, 6s, and 9s and 8s can look alike. So be sure that that's clear. Also, when you are counter offering, a lot of us use zip forms and other types of platforms. Just go back in and change the number and resubmit it when it's starting to get illegible. So don't keep doing a bunch of scratch outs. The other issue we've seen before in here is that when the contract goes back and forth is the lack of initials. And there was a situation we've had several years ago where a contract was going back and forth between 395, 400, and 405. The contract had maybe 5 or 6 offers and counter offers back and forth, and there was a series of initials. And when we got to closing on this cash deal, the seller thought the deal was 405, as did the real estate agents. The buyer said it was 400. I looked at the contract, I pulled it out and said, well, your initials are right here. And this buyer pulled out all 6 versions of the offers. And when you lined them up, you could see that initials were there, except there was only 1 initial on the last counter on the final offer. I think this buyer was trying to pull a fast one on everybody because when he sent it back, he said, hey, I'm okay with this, let's move forward. So he knew it was at 405, but never had his initials. So what happens in that situation? It's a real estate agent's duty to make sure that all initials are provided, everything's dated, and everything's initialed. All changes are initialed, and they failed to do so. So the broker and the real estate agent and I talked. I said, look, I know this guy has taken advantage of you in this situation, but what can you do? He knows what's going on and he knows how to play the game. So unfortunately, my real estate agent had to reduce their commission by $5,000 to make the deal work. So the price can be a big problem. Don't overlook that and be sure that you're very careful on that.
Hey, Gary, couple more questions that are We've seen a couple of similar ones. So when you're identifying the property, and it's two different addresses, do you put both addresses in the address block?
Yes.
And is it okay to also use the lot and block and other information on the tax records to identify the property?
I would 100% recommend you use a lot, block, and phase and subdivision information on the on that. Absolutely. The more information you can put from the tax records on there, the better off you're going to be.
Okay.
Absolutely. All right. Earnest money. Boy, we could do what, 2 hours on this, Matt? Earnest money is such a mess now. So the Real Estate Commission about 1.5 years or 2 ago horrifically screwed this up. In the past, actually, let's talk about the statute. The statute, which is 4057-136. What that says is that when you are holding money belonging to another, you may not release that earnest money or escrow money, period, whatever type of money that is, if you're a real estate agent, unless you have a signed release, a court order, mediation, or arbitration, or interpleader. Now, the problem is the statute goes on to say, unless there's no other reasonable interpretation of the contract. So it does have a qualifier, unless there's no other reasonable interpretation of the contract. So I had a broker one time that in one of these provisions in the contract failed. The contract clearly said earnest money to be released to the buyer. Seller wouldn't respond to anything. You know, they could get in touch with the seller. So the real estate broker went ahead and released the money back to the buyer, which they should have, because the contract clearly says earnest money is to be released to the buyer in that situation. And the law says, unless there's no other reasonable interpretation. There is no other reasonable interpretation. The seller finally appears, files a grievance against the broker, and unfortunately they took that case all the way to a full hearing at the Real Estate Commission. So I argued for almost 2 hours for this real estate broker that the Real Estate Commission was not following the law, because it says unless there's no other reasonable interpretation. Unfortunately, the one commissioner said it's not our job to interpret the contract, and I told her exactly it was her job, because that's what the statute requires you to do, unless there's no other reasonable interpretation. So you as the board have to determine whether there's no other reasonable interpretation when a grievance is filed. They said nope, and they issued an order against my client. They only gave him a private reprimand, but they issued an order saying that from here on out, y'all may not release earnest money, period, without a signed release, court order, mediation, arbitration, or interplea. So they just threw out part of the statute. So essentially, they rewrote the law. And so at that point, as I predicted to them, all the real estate brokerages would get out of holding earnest money. And that day, pretty much every agency I represented got out of holding earnest money. And even since the pandemic has started, I know Coldwell Banker has also got out of holding earnest money. Matt, are y'all holding earnest money still? Keller Williams, so a lot of Keller Williams are no longer holding it. John, are you holding? No. So, I mean, the two of them right there, very good brokers right there telling you they're not holding it. I could go through a list of agencies that are not holding it. So I don't think how many people are holding it. Did we put the poll numbers up there on that one? John, did you see the poll numbers on how many people were holding earnest money?
Okay, Kathleen's got here we go, right here.
There you go. 72% of your agencies aren't holding. Of people here, and there's over 300 people, I think, on this, 293 people, 298. 72% of your brokers are not holding earnest money. So that's because that's coming to be a big problem for you guys. So what's happened now is you're passing that off usually to the closing attorney to hold, and that's fine. We hold earnest money for all the closings we do. We hold earnest money. It's not a problem at all. But with that comes other problems for you. So your problem now isn't releasing earnest money. Your problem is collecting it and making sure that it's there. And so let me talk about that for a second and hopefully avoid you having a grievance against you. So if you write a contract for me today, I want to buy a house, and you write the contract and you write $1,000 earnest money to be held by Blair Cato. And you submit that to the seller, and we negotiate, and we get that contract ratified. And then you send that contract over to me, over to Blair Cato to be closed. Do you have the earnest money in hand? Because when you submit that contract to the other side, you're saying you have the earnest money in hand when you check 4A. So a lot of what's happening I'm seeing is that the contract will say $1,000 earnest money to be paid by check to be held by Blair Cato. You don't have the check. And what's happening is that once the contract's signed, you tell your seller, you need to get with Blair Cato, or your buyer, you need to get with Blair Cato, and you need to get the earnest money down to them. And then your buyer gets busy and the earnest money never comes down to us, and you never follow up. And the next thing you know, the contract falls through due to fault of the buyer, and the seller says, I want the earnest money. And guess who doesn't have earnest money? So that's going to be a big area of concern for all agents, that when you're writing contracts, you need to make sure that if your agency is not holding that earnest money, that either we properly denote that in the contract, or you're seeing the check cut and being deposited. Now, luckily for you, if you're using Blair Cato, we have an app called Zocum that your client can simultaneously deposit the money, just like they deposit money in their checking account with us. They can immediately do it like that. And so you can make sure that it's been done. So you have to be careful making sure you're following up on this earnest money.
So you recommend actually getting a confirmation from the attorney, if the attorney's holding it, getting a confirmation that they've received the earnest money?
Either that, or if you're using an app such as the Zocum app, have the buyer who's submitting the money through the app, have them do a screenshot showing the successful deposit of the money. Absolutely, you need to have some proof, because the last thing you want to have happen is you don't collect the money, and they don't send the money to the lawyer, and the next thing you know, no money's been paid and you're in trouble over that. That will get you in trouble. The grievances, if you go back and look over the last 5 or 6 years, you will see grievances against agents when deals fell through, earnest money was listed in the contract, and the agent did not follow up getting the earnest money. So that is a big area of concern for y'all right now, particularly with COVID. How are you following up to make sure that money is getting from the buyer to us? Most lawyers will let the money be handled in several different ways. They'll let you mail the money. They'll let it be overnighted. You can drop it off to their office. The client can drop it off. And like I said, our office has an app called Zocum, Z-O-C-C-A-M. Sorry, I'm stumbling over my words today. I had about 2 hours sleep last night. I'm taking some medication, and it literally won't let me sleep. It's like 2 hours a night. It's really crappy. But anyway, all right. Let's talk about earnest money, paragraph 4. So you have a couple of options under paragraph 4 for earnest money. Under paragraph A, you can write the amount of earnest money that's being paid by check, cash, or other, wire, whatever you want. B is for additional earnest money, and then C is where the earnest money is being held. One thing you can do, and because of the ruling of the commission, one of the things I like seeing done is you can put 0 earnest money under A, and then under B, put $1,000 earnest money, or whatever the earnest money is going to be delivered on or before blank. So you could say 24 hours after ratification, money held by Blair Cato. And then that gives you 24 hours after the ratification to follow up with the buyer to make sure that the money gets down to Blair Cato. So that would be one way of doing it. The other reason I like doing that, and I've seen people start doing this as well, is put 0 earnest money, $1,000 additional earnest money to be delivered on or before completion of due diligence. And the reason I see people doing that is because earnest money, even though the due diligence period is clear that the money would go back to the buyer if the buyer cancels during the due diligence, I have seen sellers who refuse to sign the release. And as y'all know, as I've said it already today, without the signed release, court order, mediation, arbitration, or interpleader, the money can't be released. And so a seller could hold up the release of your buyer's earnest money. So we have seen that being done before as well. Now, paragraph D just restates what we've talked about how the money can't be released unless you follow the 40-57-136. One thing that we did down here at the bottom on, I think this might have been on one of the revisions we did. Let me highlight this. This is a very nice provision that I believe would help you try to talk some sense into your client when they are being unreasonable and refusing to release the earnest money. If a court action is brought by either the escrow agent or one of the parties to the contract, the non-prevailing party, that means the party that loses in the action, is responsible for the winning party's attorney fees and court costs, as well as the court can give treble damages. That means 3 times. So if you are holding $2,000 earnest money, the seller should be releasing the money because the buyer canceled during due diligence and the seller has no reasonable basis to refuse to sign the release. The buyer has to go to court. The seller would not only be required, could be required to release the $2,000 back to the buyer, but that could be trebled up to $6,000, as well as they could wind up having to pay attorney fees for the buyer in that situation. So that's a good provision that when you know that your client is being unreasonable, that you might want to point that out to them and say, look, I'm not taking sides in this. I just want you to be aware of the risk that you have if you are deemed to be incorrect in your refusal to release the earnest money. All right. Let's now roll over to
Gary, one more question. We've seen a couple places is if we do $0 earnest money in section A, and write in section B, that's what you're saying to do for if you're not in possession of earnest money, you write 0 in A and write B, and then when it's going to be deposited, right? And so
absolutely, if you don't have it in possession, I write 0 in A, and then or if you know that the attorney doesn't have it. We're starting to get earnest money when people write contracts and they're negotiating, they're close. We sometimes go ahead and have the buyers go ahead and send us the money, but if you know that the escrow agent, it doesn't have the money or the check's not in your possession, go ahead and write 0 and do 1,000. One other thing on there that's a misconception in real estate is there is no requirement to have earnest money to have a contract. A lot of people say, oh, you have to have consideration. That is true. You have to have consideration in a contract. Earnest money is not necessarily the consideration. The promises within the contract are the consideration, or is the consideration. So you do not have to have earnest money to have a contract.
Could you give an example of we're getting a lot of questions about that, about how you would write that in B? Like, can you give an example of that? Would you go to paragraph 18 to write an explanation of when that's going to be deposited? Like, you have one question about, would it be delivered, and is it okay to say within 48 hours of acceptance? Should you say?
Yeah, you can write anything you want. You can put 0 in A and then 1,000 in B, and then right over there where it says to be delivered on or before. If you can get it to work, you can write in there, or you can go over here in the margin. Within 24 hours of ratification, within 48 hours of acceptance, or whatever I would prefer you use ratification, not acceptance. You could also say, within 48 hours of presentation of contract to you, to the seller, you could put, within 24 hours of the completion of the due diligence, within 10 days of ratification, whatever you and your client wants to do, that would be perfectly fine. Now, there is a good question that Karen Hood has here. If the seller refuses to release the earnest money, can they still sell their home to someone else, or to be considered under contract still? The answer is yes, you can sell it to someone else. Once you know the contract is not going through, you may then sell the property to somebody else. We're now just disputing the earnest money. We're not disputing selling the property. You got to be careful with that, though, because if the buyer says, no, we're still trying to buy this house, then the seller has to be careful about accepting another contract. But if it's clear that neither party is going to move forward on this contract, that the contract's dead, but now we're just arguing over earnest money, put in writing, we are terminating this contract. We understand that earnest money is under dispute, and then your seller can go ahead and sell the house to somebody else. If the buyer's defaulted, they absolutely can do so because the seller has a duty to mitigate their damages. So yes, and the reason that is a buyer can't refuse to sign the release on the earnest money as a way to just tie your house up forever so that you can't sell it to somebody else. Just can't do that. Okay? Anything else on that, Matt?
I was just going to say that one of the keys with that is we released a new release 2 years ago, I think, that has the 3 blanks, and we still are seeing a lot of people using the old release. That's just one release. That's a termination and a release of earnest money and release of contract all together. The new form, make sure you guys are using the new form that has 3 separate sections. That's a termination of contract, release of contract, and release of earnest money, and that defines how all that's going to work, Karen.
Right. And 2 other questions on earnest money before we move on. Another one, if the money's been given to the attorney, the deal comes through, and it doesn't come, and they never sign the contract, it's never ratified, do we still have to get a release? No, we can give it back. So if you submit the money to me today and you're negotiating a contract and it just doesn't come to fruition, it's not ratified, and your client decides to move on and not buy a house, we can release that earnest money. Just like your brokerage, though, we cannot release earnest money until it's cleared the bank. If your client's given us a wire, those are good funds, so we can immediately release that money. However, we cannot release money if your client gives us a check, a personal check, and we've deposited that. We have to wait 10 business days, just like your brokerage had to, until that check clears. I actually had a client one time where they gave us $5,000 earnest money check, and then the contract didn't happen, so then they wanted the money back, and the agent said, well, that's just the cost of doing business for you if it bounces. I'm like, I don't know where you come from, but I'm not taking a $5,000 chance. I don't think your brokerage would as well. So no, we have to wait, make sure it clears the bank. The last question I'll answer on that, unless Matt has some other ones, somebody asked, is what happens if you don't know who the closing attorney is or who's going to hold the money? Can you put closing attorney to be determined later? Sure, but you want to make sure that you're just doing that properly by using 0 and A and putting the money in B, and then you're denoting in B that, you know, it's within 48 hours of ratification or whatever, or within 24 hours of the closing attorney being identified or selected, so that there's a trigger as to when that has to be done by.
So
right.
Gary, we're getting a lot of questions about releasing and how releases work, and do they have to sign? What if the seller refuses to sign the release and things like that? Do you want to address that later on when it comes to releasing?
Yeah, I mean, we can address that later on if you want to do that later.
I mean, you can address it now. We're just getting a lot of questions about, and I think one of the keys is making sure that you're using the proper release, because the termination is you can explain it. Termination is unilateral. So once it's terminated, it's done. You do what you want. The release of earnest money is separate, right?
Absolutely. And CCRA created this release. You're not required to use it. It's an excellent release. We spent almost an entire year drafting this and debating it and making sure that it covers everything. But once the party notifies you that they're terminating the contract, they're not moving forward, you're okay. So if a buyer says, I'm not buying the house, I'm terminating the contract, once you have something in writing from them, whether it's an email or a text, now the contract's terminated and your seller can move forward selling it to someone else while you are trying to determine the release of the earnest money. It is in your best interest. It is in your client's best interest to use the form release that we drafted and at least get the section signed that says, we agree the contract's terminated. We haven't agreed as to the release of earnest money. That is the best practice you could do, because later you don't want somebody coming up going, well, I was just blowing off steam. I wasn't really terminating the contract. We were still moving forward, and now the seller's moved on without it. So you absolutely need to get something in writing. Best practice would be to use the CCRA release that we've come up with and at least get the part signed that says we've terminated the contract and we are still disputing release of earnest money.
Hey, Gary and Matt, quick note here. We're getting a ton of questions in chats, and we appreciate that. We're gonna record all these questions. If we don't have a chance to answer your questions specifically today, we will go back and make sure these questions get answered either in some type of format to you personally or to the whole CCRA association as a whole. So we appreciate the questions, but we just, for time's sake, we're going to move forward.
Yeah. All right. So that moves us over now to page 2, transaction cost. Yes, sir.
I was just going to say, do we want to say, I don't know what your time is afterwards, but we want to say if you have questions, we'll try to keep a list of questions and then maybe just have a short question and answer session after time.
Yeah, we can try that. We'll see how quickly we can get done. That's no problem. All right, transaction cost. We fixed this in 2008. Back in the prior contract, when you were asking a seller to pay closing costs, there were different boxes. It was closing costs, discount points, and prepaid. And what was happening is somebody wanted the seller to pay $1,000 in closing costs. They would put $1,000 in closing costs, $1,000 in prepaid, $1,000 in discount points. And what they were really intending it to be is just $1,000, but the way that contract was written now, that was they were getting $1,000 toward each item. So in 2006 through 8, when we wrote this, we changed it and said that buyer transaction costs are basically everything. They're closing costs, prepaid items, insurance, any kinds of insurance, discount points, all costs to obtain owner's association information, interest, title fees, you name it, we've pretty much covered it under the provision. Seller's transaction costs are deed preparation and deed stamps. That's the big part right there. Look right there, you'll see that deed stamps in our market under our contract are paid by the seller. That's not the same way in every market. Some markets are buyer pay, some markets they split it 50-50. You also need to be careful when you're looking at a builder contract. A lot of the builders now have moved deed stamps from sellers to buyers. And you also got to be very careful with government contracts, FHA, VA, where they are Department of Veteran Affairs or Fannie Mae or Freddie Mac, those companies or those government entities for selling properties. Governments cannot pay deed stamps. So government agencies and quasi-government agencies will move that over to the buyer. So make sure you understand that. The seller also has to pay all the costs to deliver marketable title, pay all satisfactions, and your brokerage fees and any expenses for the seller's attorney that are included. So we've defined that very broadly, and I think it's done very well. All right, Now, under paragraph 5, your client has the decision under A or B. A is the buyer is going to pay the buyer's cost and seller is going to pay the seller's cost as defined above, except for the buyer has to pay, excuse me, the seller has to pay for non-allowables if the financing type is VA and FHA. What are non-allowables? Your guess today is as good as mine. Those change every single day, it seems like. Sometimes lenders will tell you that the VA doesn't have a problem with the CL 100. Other lenders tell you they do. So you're just going to have to get with your lender to see what they are considering non-allowables now, because it changes so much. B is you want the seller to pay a certain portion of the buyer's closing costs, which would include non-allowables first. So if you put in there $1,000 and it's a VA loan and there's $100 of non-allowables, the $100 gets applied to that $1,000 first, and that leaves $900 more to pay other things. If the amount exceeds, so you put in $1,000 in closing costs and the buyer has $5,000 in closing costs, the buyer pays the difference, obviously. But if the seller agrees to pay, say, $5,000 in closing costs, but the buyer only has $1,000, the seller agrees to pay $5,000 and the buyer only has $1,000, then the seller gets the difference back. The buyer doesn't just get a credit. Very important to understand that. And we see this a lot where buyers, agents will put seller to pay $5,000 in closing costs, and yet the buyer is doing a no closing cost loan. So you just gave away $5,000 of your client's money. So before you just arbitrarily pull a number out and add that to the closing, you need to know exactly what the closing costs are going to be with the particular loan that your client is selecting. I see this daily, that the closing costs are $3,000, and then the buyer's credit for closing costs from the seller on the HUD winds up being $2,800. So you just gave away $200 of your client's money. Sometimes it's because there's not enough closing costs to eat up what the seller's agreed to pay. Other times it's because the buyer has to have a certain amount of money in the transaction. So certain types of loan products require the buyer to at least have 1% or 3% or 5% or whatever it may be. So if the closing cost reduces it to the point where the buyer doesn't have that much money in the transaction, then they start limiting the amount of money on the seller closing costs. So don't give your clients money away. It's embarrassing at closing table when they sit there and look at it and go, I thought the seller was going to pay $5,000 in closing costs. And you say, well, you had to have a certain amount of money in the transaction, or you didn't have $5,000 in closing costs, you only had $3,000. You can see the little mouse running in the buyer's head going, well, why did I raise the price of this house from $150,000 to $155,000 so I could get $5,000 in closing costs? Why didn't I raise it just to $153,000? So quickly they realize that you didn't do it right. Okay, so be very, very careful with that. It's embarrassing for you, and it's not going to help you get any more referrals. All right, paragraph 6, financing. This says buyer's obligation of the contract is or is not contingent on buyer obtaining financing. In our industry, we have this idea that we just check it all the time. Quit doing that. Talk with your buyer and find out if they truly want the property, the purchase of the property, to be contingent on financing. Not everybody needs it contingent on financing. Sometimes people are planning on buying the house and they have the house they're living in. They're not planning on selling it for 6 months or 8 months or 9 months. And they already know they qualify for financing owning 2 houses. Sometimes people are going to keep the house or give it to a family member. And so selling that house is not going to be a burden for them, and they already are approved. Sometimes you're dealing with people that are millionaires or very, very rich and buying a house for their child for $150,000. They're going to get approved for the loan. Keep in mind, when you submit a non-contingent contract, it's a better offer. Some sellers will accept a non-contingent contract over a better priced offer because they know it's not going to get denied for financing. So don't always just check it's contingent on financing. Ask your buyer if in fact they need it and want it to be there, and have that discussion with your buyer and make sure they understand the ramifications both ways. Now, we had a big fight over this at the contract committee back in 2007, and quite frankly, I think Matt would agree, we continue to fight over this next provision all the time. Buyer and seller acknowledges that all financing contingencies herein automatically expire 5 business days prior to not including the closing date set forth in paragraph 7. So you have to start with the day of closing, and you don't count the day of closing. You start the day before, and then you count back 5 business days. That is when the financing contingency automatically expires. As a real estate agent representing a buyer, you should be calendaring that about 7 or 8 business days prior to closing, and you should be having the conversation with the lender and with your buyer to make sure they understand that they are coming up on the expiration of the financing contingency, and make sure that they are comfortable that they are going to qualify for the loan. If they are not going to qualify for the loan, you need to get the lender to go ahead and provide you the denial letter if your buyer does not want to take the chance of having their financing contingency expire. Got to be sure you do that. That's going to fall on you to make sure that that is happening. Now, I understand that a lot of people don't like this provision. Keep in mind, when we wrote this contract, we wrote it for buyer's agents, seller's agents, and agents who do both sides. The selling agents, listing agents were adamant that the seller needs to know at some point whether these people have financing or not. Now, I also understand that when do we know we have loan approval? John, when do we have loan approval? I know you'll get this right. I'll answer it for him. When we fund. That's when you have loan approval, when you fund. Because up until the time it funds, the lender could go out of business. The lender may find out that your buyer went and bought a $150,000 Escalade last night and no longer qualifies for the loan. They can find out all things right up until the minute they give you a funding number and authorize you to cut the checks. So the reality of it is you truly don't have approval for a loan until it funds. But at least the 5 days gives everybody warms and fuzzies and lets the seller know that, okay, we're 2 days away from closing. Now they can't cancel for financing. I feel okay. I can go ahead and start packing the U-Haul, and I can go ahead and start getting ready to move. No, it's not a 100% perfect provision. We know it at the contract committee, but we have to do something. And so far, it seems to have worked at least well enough to keep it in there. All right. If buyer subsequently fails to close during that 4 or 5 day period, then the buyer is deemed in default of the contract. And at that point, earnest money is to be released to seller. So some of you are probably saying, well, why do you have all of that information in there now about where earnest money will be released if the court's telling us we need to have a sign release, court order, or mediation? We still have that in there for the situations to help direct the clients to understand who's supposed to get the money. So if this situation happened, you could point to it and say, sorry, buyer, it's the day before closing. Now you're saying you don't get financing. Your financing contingency is expired. So you're now in default and the money should be released to the seller. So now you have that ability to explain that to your client, and your client can see it in black and white. It also helps our judges, our magistrates understand in the contract who's to get the money, and it hopefully directs them so they don't just decide what they want to do at court, which typically is what happens. All right, moving on to paragraph 6A, financing type. On the last revision, or one of the last revisions we did, we added other types of financing. We used to have just conventional, I think, an FHA and VA. We added USDA, state housing, FHA, housing conventional, state housing, seller, cash, and other. We added those provisions because we are a military town. We have a lot of people who are PCSing into town that need houses on short, or maybe moving, may need to sell their house on a short time frame, or may need to buy a house on a short time frame when they move. We also have a lot of people who are doing USDA loans. We know that if you're doing a USDA loan, even in normal times, that's not closing in 15 days. That's a 45-day close in most cases. We know if you're doing a state housing loan, that's probably going to be a little bit pushing it to get it done in 30 days, maybe 45 days is better. And so as a seller, I need to know exactly what type of loan you're using. So when you tell me you're closing in 15 days and you check USDA state housing grant money, I know that's not happening. I know that's fool's gold. So that now a good listing agent can sit down with a seller and say, hey, let's really look at this and gauge whether they really can close in this time frame. The next provision says if buyers or buyer's agent will immediately notify seller or seller's agent if the financing type changes. This is interesting to note on this. If the change modifies the terms of the contract, then seller will have the option of agreeing with the change or voiding it. So if I have selected FHA and now I'm going to cash, as a buyer, all I have to do is notify you. You don't have to give me permission to do that, because nothing in my change has modified the terms of the contract as in immaterial terms. Okay. Now, if I am going from, say, conventional to VA, and now it's going to cause a 15-day delay on the closing, or it's going to require you to pay a non-allowable fee, such as a termite report. Now that has changed the terms of the contract, and now you as the seller have the option of either agreeing or voiding the contract. Now, if the seller voids the contract, money goes back to the buyer. All right. And the question we have, and Jennifer, you're right on. If the mortgage company changes it, do you have to notify the seller side? You're supposed to immediately notify the seller side. Be careful when you notify them. What you're going to do is notify them and say, hey, the lender's changed this from VA to conventional or conventional or whatever. Want to notify you that it's not going to change any of the terms of the contract and we're moving forward. But if the lender changes it from conventional to FHA and now there's fees that the buyer, something the seller has to do, or additional fees or delays, you have to notify them immediately and let them know. You need to let us know whether you're going to accept the change or if you're going to void the contract. It does not give a time frame for the seller to void or agree. But once the seller acts in such a manner that the buyer can rely on those actions, the seller is pretty much stuck. So if Jennifer calls me and tells me, hey, the lender's changed from conventional to VA, and I say, all right, I'm fine with that. Or let me talk to my seller, I'll let you know today. And now 8 days have gone by and we're now negotiating repair addendums and things of that nature. My actions and my seller's actions have given the buyer the belief that we're moving forward. They can't then come down 5 days before closing and go, you know what, I changed my mind, I'm not going to accept that. So once there's detrimental reliance, the buyer has the right to rely on that and move forward. But you'll need to talk with your attorney about that as that happens. We do provide a note that if buyer utilizes FHA or VA financing, the lender requires the addendum, which the parties will agree to sign. And other than that, I think that's about all we need to go over in that section. All right, so let's talk about B. I hope everybody's following this, the application for financing. If lender financing is being used, which is the vast majority of our closings, the buyer has 5 business days from the date of contract acceptance to apply for financing from lender of their choice. And the question I usually get now is, doesn't the pre-approval letter work? No, that does not work. In order to properly apply for financing, you have to do, and I don't remember the entire acronym, but if y'all remember from the continuing education core class a couple years ago, it was called aliens. You had to provide the address, the loan amount, the interest rate that you want to go with the lender, social security number. Once you provide that to the lender and pay the fee to the lender for any costs they may have that they require upfront fees, such as appraisal, at that point you are deemed to have applied for the loan. That also means have submitting your 1003. That's what the lender is going to require. But if all you've done is gotten a pre-approval letter, your client has not applied for the loan. All right, that's what that provision talks about. All right, going under B1, if you fail to apply, the buyer fails to apply within the 5 business days, buyer's in default, and seller has the option of voiding the contract and earnest money being released to seller, not buyer, to seller. So if your buyer signs a contract and then goes to the beach for 10 days and hasn't applied for the loan within that 5 business day period, the seller can void the contract and keep that earnest money. Again, if the seller does not void the contract in a reasonable, timely manner, or acts in such a manner that makes the buyer believe that it's okay and we're just moving forward, the seller can't then turn around and go, you know what, 6 weeks ago you didn't apply for the loan within the 5 days, so now we'll cancel the contract. That doesn't work. Should the loan be denied while subject to financing contingency, the contract will be voided and earnest money will be released to the buyer. See paragraph 4D. That's talking about how the earnest money. So it's weird, though, it goes back here to paragraph 2. If the loan is rejected by the initial lender or subsequent lender, buyer or buyer's agent must give written notice of each occurrence to the seller's agent immediately. The seller has the option of continuing with or voiding the contract. So if the seller wants to void the contract, the earnest money will be released to the buyer, which follows 1. But they can also offer the buyer the option of going out and applying for the loan with a different lender. So if they're using a very conservative lender, right now in this coronavirus, it maybe has very high rating numbers that are requiring a 700 credit score, and your client's got a 680, and there's another lender out there who will do 650 loans. You may, as a seller, say, hey, why don't you try this lender? And if the buyer agrees, then y'all can continue the contract. If the buyer makes a material change in their contract, this is paragraph 3. If a buyer makes a material change in their financial condition after contract acceptance that affects their ability to get the loan, then the buyer's in default. What this is eliminating is the buyer wants to get out of the contract and they go out and buy a new car, so they no longer qualify, so they now can get out of the loan. That in and of itself would be a breach of contract by the buyer, and they would be in default. And then paragraph 4 there just gives the buyer permission to